So this past week, we did not have class because they canceled everything. But I did tell you guys that this is an important area that we definitely need to touch on. And so I am going to go through the lecture just as if I had been there with you. This one is going to be a little bit longer, but only because I broke out the slides to where there's many examples. And this is something that we've already gone over in other classes, so you may have already heard it. Again, this is just to drive home how important this is because this is civil litigation, and the very core issue here is whether or not we're in the right court, whether or not it's the right jurisdiction, it's the right venue, and if it's not, then the whole case can get thrown out. So that's why this is so very important. So let's get started. All right, so let's talk about the courts. There are two types of courts. There's federal and state. And technically, we can go into the fact that there are actually other courts like the municipalities, like the cities. We're not going to worry ourselves with that. We're just focusing on these two. At the very top of the federal court hierarchy is, of course, the U.S. Supreme Court. Then underneath that, you're going to have the U.S. Court of Appeals, and then you'll have the U.S. Court of Appeals for the Federal Circuit. And then if you look underneath that, you will see that there is a U.S. tax court, you have the district courts, the Court of International Trade, and then you have the claims courts. Under the state, you have the state Supreme Court at the very top. Then you have the intermediate appellate courts. Then you have your superior court, which is kind of like your general jurisdiction court. Then off of that, you have the municipal courts, which are going to be your cities, like I already mentioned. And then you're going to have your county courts of limited jurisdiction. County courts of limited jurisdiction are going to be courts that are like juvenile court, magistrate court. Those are courts that if you need to appeal, it's going to go to the superior court for an appeal first before it goes to the intermediate appellate courts and then on up from there. So trial courts can be a lower court, which could be the inferior courts as well. The inferior courts are going to be those that are going to be like the juvenile courts and the magistrate court that are going to have to appeal to the superior courts. The rest of the trial courts, like I said, are going to be more along the lines of the superior, the U.S. district courts, things like that, because those are going to be your trial courts. This is where you have people who are filing their pleadings, they're presenting their evidence. This is where the case is going to originate. All right, this is the path that a litigation case is supposed to take. You have an event that happens to the client comes in and hires, and you will start with gathering the facts and investigating the claim. All of these things are going to be what ends up going into the complaint, and then you'll file it, you'll issue the summons, they will get served, and then the defendant is in the response phase. Now, I know it says that the defendant responds, but it could be that there's no response. This is an absolute fact. When it comes to the law, silence is an affirmative answer. Okay, so if you say nothing, you are essentially saying, I agree with it. That's fine, which then allows for the defendant to be served with a default judgment. The plaintiff can go in and say, look, they didn't respond in the time that was allowed. Therefore, I'm entitled to this default judgment, and the court can grant it to them. Now, the defendant has the right to also file either a motion to dismiss, and it's going to be based off of some kind of defect like they weren't served properly, or it's missing documents or something along those lines, or they can file an answer. Now, if they file a motion, it's going to have to go through the phase where the judge is going to have to decide whether or not they're going to grant it, and they may allow for the plaintiff to amend the complaint, or they just may dismiss it altogether. But I don't want to say it's definitively dismissed altogether because I do know of some cases where that has not been what happened. In fact, there was one recently where a lady had filed for a wrongful death, sort of. She actually ended up filing the wrong thing. She was doing it on her own, and she was doing it in federal court. This is in Indiana. And anyhow, she filed it under a civil rights action. And it was over the death of her child, who was an older child. And the cops came in and they investigated it. And they said that it was a suspicious death. And then they turned around and said, oh, wait, It's your kid. Oh, we know your kid. Your kid is trans and your kid also has mental health issues. Therefore, it's no longer suspicious circumstances. And so they just ruled it as a suicide. So anyhow, she's gone in and she's had to be, out of pocket investigating, also with time. Time is money. But anyhow, so she filed this under a civil rights action. And so she gets this order back. And a friend of mine had told me about the case. And she said, I'm just curious. She goes, can you just explain this to me? And I looked at it and I said, oh, well, the judge is giving her the right to amend it. She said, I know that. She said, she's already working on that. She was like, but why? And the reason why is because in her original action, she didn't have standing to file a civil rights action, simply because her child is responsible for their own civil rights action. And there's no standing there. That's an issue. But her child's deceased, and she should have gone in technically, and she should have filed a tort claim. They should have filed for like a wrongful death. They should have filed for negligence. They should have filed for all those things. But she made a good enough argument in her original complaint to the court that the court did not grant the motion to dismiss that the state filed, and they allowed her to go back in and amend it. So again, I just want to make it clear that it's not always the case, but typically courts will just be like, they'll throw it out. But I think this judge just kind of took pity on her because the judge's order was a little more detailed than what I've seen in other cases. But I digress. Anyhow, so defendant answers if there is if there's an amendment also, they will go in and answer it. Then we go into the discovery and the pretrial phase. And this is where we start gathering the evidence. We start looking at what the other side is doing. And we take away that ability to have that, aha, gotcha, moment, because we don't want any of that. We want to be able to prepare as much as possible when we get into court, or be prepared when we get into court, rather. Then it goes to trial, it goes to appeal, and it goes to the post-appeal proceedings. Now, this does not take into account the fact that these cases can also go through alternative dispute resolution, which is like your mediation and your arbitration. And it can do that before it hits the trial phase, and it can be settled. But that's just not on here. Anyhow, I digress. Let's keep going. So the Court of Appeals is also known as an appellate court, and it is the court that is right above the trial court. It handles the appeals that involve trial court errors. I know that we all know somebody who has seen a case, particularly go before like the Supreme Court, and they'll go, oh, well, I don't understand how this didn't get granted or how this got thrown out. This is all about the questions that are put before the court. Okay, so whatever questions are in the appellate court are going to be the same questions that kind of move forward if they don't feel that the appellate court has handled them in the proper way. But it would be something that's like, hey, we wanted to give the jury an instruction that said, if this happened, then this should be the outcome. And the judge said, no, we're not going to do that. So it might be that the question before the court is, did the judge err in deciding that they were not going to present this jury instruction? It might be that you have something to where maybe there was some kind of evidence that was suppressed, or maybe testimony that was suppressed that might have been more beneficial to the defendant. And this is the whole thing where the judge will have to balance in these types of cases. Is it more prejudicial or is it probative? So if it's prejudicial to the defendant, then they will typically go ahead and suppress it. Or is it probative? Again, this is one of those things where we're not looking to give the jury, we're not looking to overwhelm them. And I know this sounds completely weird, particularly when you start talking about the fact that you see this kind of come up in criminal trials a lot, where you'll have somebody who is in court. Actually, I'll take O.J. Simpson, for example. O.J. Simpson is a good example of where they had like these previous domestic violence situations with Nicole Brown Simpson, and they suppressed them. Anyhow, they did that because they felt that this was too prejudicial to him. Same thing happened with Derek Chauvin whenever he went before the court as well. They decided to take away the jury's ability to learn about any other cases of potential police brutality that he had gone through. So again, this is where, though, we're just simply asking questions. Was there an error? Okay, so the Court of Appeals is not going to rehear the entire case. But what they will do is they will either affirm the decision, they will remand the decision. So affirming it is saying, I agree. They will reverse the decision and completely overturn it, or they can remand it. And that basically means that they're giving it back to the original court, and they're saying, listen, they usually send instructions and they say, this is how this should have been applied. So therefore, take these instructions into account and make the proper decision. Now, they have to review every single appeal that goes before the court. They don't have the right to pick and choose. And this is a very key thing that you need to keep in mind. Now, the Supreme Court is known as the court of last resort, and that's because that's where cases essentially go to die. There is nothing past the Supreme Court that can be done except for the legislature to come in and create some kind of law based around the particular case. This is the highest level in the federal court, and there are state court versions. Now, this is not always a court of last resort, though, for state appeals, and that's because if there is a federal question or there is a constitutional violation, this case can continue to go into the federal system and on up the ladder. Now, the difference here between the Supreme Court and the appellate court is that they don't have to hear every single case. They have the right to pick and choose which ones that they want. And what they're looking for is something that they're looking for the individual circumstances plus the impact that it's going to have on society as a whole. So if it is something that is going to potentially, impact everybody, but it's also going ahead and addressing this individual, then they'll go ahead and take the case, provided that it makes it through, the process. They will also do the same thing with affirming, reversing, and remanding as well. Now let's talk about jurisdiction. All right. Now we have to look at the three prerequisites to an actual claim that the court has to have. And we're going to talk about all of these in detail, so don't worry about it. They have to have the jurisdiction over the parties or sometimes things. It might be like real property or something like that. Then you have to have jurisdiction over the subject matter. And then you also have to have the proper venue. All right, first let's talk about personal jurisdiction. All right, with personal jurisdiction, you have three types. You have in personam, in rem jurisdiction, and quasi in rem jurisdiction. And again, I know some of you have already heard this whole entire lecture before, but again, this is like the backbone to any civil litigation case, so I'm going to drive this point home. All right, personal jurisdiction is what allows the court the authority to determine the rights and liabilities of a person or entity in a lawsuit. Personal jurisdiction is also called in personam jurisdiction, which just translates to personal jurisdiction. It is for individuals and entities is used very loosely here. And that is because I have corporations and partnerships and stuff like that. Corporations definitely become living, breathing entities just like you and I. But the difference here is that some jurisdictions require partnerships to be filed with the Secretary of State. Some of them only require that certain types of partnerships get filed with the state. But if it does get filed, it's going to fall under this same type of thing. Otherwise, it's not going to be an issue. It won't apply here. Then the court is going to have to ask the question, would it be fair for this particular court to issue a judgment over this individual or this entity? So you have two elements that are required here. The first is laws governing the court must give the court the authority over the parties to the case, and where jurisdiction is proper by law, the jurisdiction must not violate the due process clause of the 14th Amendment. Now, notice that must and are italicized, and that's because I need to reiterate here that when you have something that says must, this is mandatory. They cannot get around this. Also, with and, you always see and or you see or. The difference here is that when you have the and, you have to have the whole entire list met. It could be 20 things. And if it says and, it's going to be all 20 of those things. You can't have 19 and it still move forward. You have to have all of them. If it says or, then you only have to have one of them, or you can have any combination thereof, but it's not going to require every single one of them in order to move forward. So just wanted to kind of step back and remind you of that. But again, we're looking to not violate the due process clause of the 14th Amendment, which states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any laws which shall abridge the privileges and or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the law. So let's talk about due process, because again, I need to kind of drive this home. You have two types. You have your substantive and your procedural. Your substantive is going to be your what rights you have, what you can expect from the government under the law, and your procedural is going to be your how. It is going to tell you what motions to file. It's going to tell you what court to use. Sometimes it'll even tell you what font to use, what margins of the paper to use, all of those types of things. Now, more specifically, with substantive due process, it is going to examine the contacts between the state, that is assuming the jurisdiction, and the defendant or the property subject to the case. This is where we're going to look at, is it going to be fair to pull this individual into this court for a judgment? They have to determine that it would not be fundamentally unfair to exercise jurisdiction. This goes back to the International Shoe case. And I don't know if you guys remember me talking about that or not, but the International Shoe case is the one where we're looking for those minimum sufficient contacts between the individual and the state to determine whether or not it is going to be fair to pull them in. We don't want to offend any kind of traditional notions of justice and fair play. So you have an example here where Anne was born and raised in Georgia. She never left the state, never had any transactions with a business outside of Georgia. Then you have Beth, who's visiting from New York. They get into a car accident. It is due to Anne's negligence, but Beth turns around and she files for damages in New York. Would this be something that is considered fundamentally fair? No, because there are absolutely no ties to New York. So when this court is going in and they're examining this, they're going to look at what kind of ties does Anne have to this particular state. And in this case, the only thing that she has is this actual accident that happened with somebody who happens to be a resident of New York. Now, the ways that you obtain jurisdiction over parties is through consent, which is essentially that saying, I agree, I waive my right to being in any other jurisdiction to be here. You get service of process while present, and service of process is where you have the sheriff or process server who serves you with the summons and the complaint. And while present means that you're in the state at the time. And then you also have the sufficient contacts, which we just talked about in a little detail. Now, with consent, we have where the party has to agree to allow the court jurisdiction. Now, one of the things that we use here is we oftentimes will go to people and we'll say, look, we don't want to have to serve you. If you can just sign this acknowledgement of service and waiver, and they can acknowledge that they have received the papers, and then they can sign a waiver that waives their constitutional right to whatever jurisdiction and venue that would have been proper had we served them. If you have two Georgia residents, we tend to go where the defendant lives, and we file there. Now, the defendant where they live could also be that it's where the company actually is. But nonetheless, we want, in these kinds of cases, we're asking them for their consent to come into the court and have it here. But that's not the only way to get consent. You have other situations where you have it by contract or agreement. And there is a very famous case that we use for this where it says parties to a contract may agree in advance to the jurisdiction of a given court to permit notice to be served by the opposing party or to waive notice altogether. Now, I'm going to give you more details about this case, but one other thing that I want to add to you here is that in terms of consent, you also have a situation to where somebody goes into the court and they file it in, say, Fulton County, and we're asking them to waive jurisdiction to consent to Fulton County. If they file an answer and they don't waive jurisdiction, then they've consented to it. So there's not going to be a going back later and trying to get out of this. All right, so I'm not going to read all of this to you, but this is essentially the national equipment rental case. And the crux of this issue was that they had an agreement where there was an agent that was put in place as part of their, contract. And so they had no idea who this person was. And so they filed in the court. And they said, was this properly served because it went to this particular agent? And the court came back and they said, yes, because the summons went to this particular person and you were aware. So they may not have actually known who this agent was, but this is something that they had the ability to fix during the contract negotiation period. This is something that they could have had, like it X'd out and everybody agreed to it. And we said, no, it's only going to go to the person, who's over the company, maybe just the president of the company. In contracts, you can essentially agree to anything as long as it's legal. So again, we're looking for the fact that they should have known that this agent existed, even if they didn't know who the actual agent was. They still had knowledge by this contract, again, even if they didn't read it, that this person existed. Now, consent is not always valid. You can have it sometimes where there is fraud, where it's overreaching, where there's some grave inconvenience, or there's a violation of the forum meaning the state, their public policy. Now, unequal bargaining power can also be a factor. I'm not going to go into this a whole lot, and that's simply because we will cover that in contracts. But I just wanted to put this out there for you so that you do know that even though consent is one of the ways in which we gain personal jurisdiction, again, there are always exceptions to the rule. Other means for consent are going to be where they waive it, which is what we talked about already. And then you also have where they don't object in time. And for federal, it is 20 days. For state, it is 30 days. This is where they're in that response phase. And they have the right at that point to come back in and say, hey, I'm not in the right jurisdiction. This is not the court where I should be doing this. And this is an affirmative defense. So these affirmative defenses are going to be things that are going to come up in cases. And they basically say, look, even if everything in this is true, it doesn't matter because of this. So for this particular case, it's not going to matter if every single fact in this whole entire case is true. And the plaintiff maybe should win the case, but it's not in the proper court. And because it's not in the proper court, you have to throw it out. So this is an example of the waiver that I was talking about earlier. And this is one where the person is not in the state. So it says very specifically right here, I have been informed that I have a constitutional right to a trial by judge or jury in my state of residence, and that I expressly waive my right to jurisdiction in the state of my residence and consent to jurisdiction in the state of Georgia, and specifically in this case, it's Fulton County Superior Court. So let's use an example. Joe's a resident of Alabama. Gwen is a resident of Georgia. He moved there after they split. She's never lived there. He filed for divorce in Alabama. She was properly served and did not file an answer. And the Alabama court granted a default divorce. Was this proper? Yes, because she didn't exercise her right to object. She did not file an answer. So therefore, it became that silent yes. Yes, I agree with this case. Yes, I agree to everything they've said. So therefore, just give it to them because I don't care. I agree. But let's change it up a little bit. He's the resident of Alabama. She's Georgia. He moved there after they split. She, again, never lived there. And he filed for divorce in Alabama. Again, she's properly served. But this time she filed an answer but didn't object. And the court granted the divorce. And this is also proper. You have to speak up. Even though she's filing an answer and she's responding, she's not fully responding. So she's still giving that silent yes, that silent consent to that particular portion of the case. All right, so now we have Shauna who's suing Christy in federal court, and she's had her served, and Christy objects to jurisdiction, and she files it within those 20 days. That makes a timely response. So Shauna comes in, she files an amended complaint that is now adding a new count. Maybe it was the fact that something else has happened. Maybe she was struck again, and this is what she's suing for. She's suing for battery. Christy didn't object to jurisdiction on the new count. Okay, so this is an amended complaint. The court maintained jurisdiction despite the original objection. Was this proper? Yes, because when there is that amendment, you still have to go back in and you have to keep doing it. This is one of those things that, if nothing else, consider it erring on the side of caution. Okay, we are, not going to stay silent. We're still going to reiterate to the court, this is the wrong court. I am not supposed to be here. All right, some other ways to get consent. We have the limited purpose jurisdiction, which is specifically used just to determine jurisdiction. This means that you're telling the court, look, I don't actually belong in this court, but I'm going to show up for this hearing and I'm going to let you determine whether or not you think I should be in this court. But I am maintaining I don't belong here. And so their objection to jurisdiction is preserved. That way, if they need to appeal it, maybe the judge decides, you know what, we do have jurisdiction and we're still going to move forward. Then the objection's been preserved, which means that when they go to the appellate court, they're saying, look, I told them, what do you say? Then we have by filing the complaint. Now, this is where you might have somebody who lives, say, in all the way down in Valdosta, Georgia. I don't know what county that is, but they live down there. And they had an incident, maybe a car accident with somebody who lives in Fulton County. If they file it in Fulton County, they cannot come back and say, I don't consent to this court. They filed it there. Of course they consented. Now, when it comes to the counterclaims, this is where the Supreme Court says, you have consent when it comes to counterclaims, but courts have been split on whether or not it means any counterclaims or just those that are related to the matter before the court. And that's because these civil litigation cases can get kind of convoluted, I guess, for lack of a better word. But you can end up having like third parties that are brought in, and you have to have a determination that's made between these other parties to determine who's actually at fault. And, you might have all of these different things that happen. And so this is where we might see something about whether or not the counterclaims are going to give rise to personal jurisdiction. Now, going back to being present in the state whenever you get served, this is also called transient jurisdiction. And this means that if they get served while they're in the state, the court can take jurisdiction over them. So you've got Joe and Gwen again, and they are married in Florida. And when they split, he moved to Alabama. She moves to Georgia to be with family. After the waiting period, she files for divorce in Georgia. Georgia, you have to be a resident for 6 months before you can file. And it can be either party as a resident for 6 months. Now, he comes to town to pick up the kids for visitation, and she has arranged for him to be served while he's there. He gets served, and now he objects to jurisdiction. Was this proper? Yes, because he's present in the state to be served at that particular time. But let's change up the facts just a little bit. She told him that he would need to come pick up the kids because she had a broken leg. They usually meet just across the Alabama border, and he arrives and she opens up the door, did not have a broken leg, and he was served, and he objects to jurisdiction. Is this proper? Yes, because she's using fraud to get him there. She's tricking him. She's making him have to come there because ordinarily they would still remain in Alabama because she would be going to him. All right, so these minimum contacts, this is where things get a little bit trickier. This is where you have the court taking jurisdiction because they have determined that there is sufficient contact between either the individual and the entity, or the entity rather, with the state. Now, again, it cannot offend traditional notions of fair play and substantial justice. This is a phrase that you'll hear a lot because it comes from International Shoe. If they find that there is sufficient contact, it means that the defendant would have expected to be hailed into court in the forum state. This means that you would expect to be sued if something happened in that particular state. And I'm going to give you a couple of examples of what these types of cases look like. So with International Shoe, I'm actually going to read this one to you because, again, this is like the backbone to this particular issue here. So with International Shoe, it was incorporated in Delaware, so keep that in mind. Its principal place of business was in St. Louis, Missouri. So now we have 2 different states, and they didn't have an office in Washington state, but they did have 11 to 13 salesmen who were residents there. They would go around, they would show products to prospective buyers, and they were paid commissions on their sales. So the state came in and they issued a notice of assessment for Shoe, and it was holding them liable for contributions to the state's unemployment compensation fund. And this was per their Washington Unemployment Compensation Act. Now, they sent notice through the mail, and they personally served the Washington salesman, okay? So in this particular case, Shoe refused to pay. They're like, we're not participating in this because they said we're not actually doing business there, okay? And so they argued that these notices were insufficient to constitute due process. Now, in this particular case, the court ruled for the state Supreme Court affirmed. Now it's been appealed to the Supreme Court. The issue before the court was, could a non-resident corporation's activities, which would be those salesmen in that state, would it make it subject a company to the jurisdiction of that particular state? And they said yes, because due process requires that where a person is not subject in personam, they have minimum sufficient contacts, okay? You're also looking for activities that are not irregular or casual, and that they are systematic and continuous for years, okay? So in this particular case, they had lots of sales that were going on out there. They had these salesmen who were going around. They were taking the orders. They were sending them back into the office. The office was sending them over to the warehouse. The warehouse was processing them. They were sending them back to the state. Again, in this particular case, they said they should have expected to be hailed into court. if something happened in Washington, they were saying that they should have expected to be sued there, just like they should have been expected to be sued in Delaware, and just like they should have been expected to be sued in Missouri in the event that something happened in either of those instances. But now they have a presence also in Washington state. Therefore, the same thing is applying. So with Burger King, I'm also going to talk to you about this one in more detail. And that's because, again, we're kind of building up from Schuh on all of the cases that truly matter to this type of thing. These are the long arm statutes and how we bring other people in. So with this particular case, you have Burger King, which is a Florida corporation, and it has its principal office in Miami. Now, they have franchisees all over, right? And whenever you have a franchisee, they are allowed to use trademarks and service marks. This would be like their logo, things like that, any kind of slogans, all of that stuff. Now, contract says that it's governed by Florida law, all right? It calls for payment on fees and any notices to go to the headquarters. Now, this particular Burger King is in Michigan, and it's a franchisee, and they got behind on their fees, and Burger King came in and terminated the franchise agreement, and they asked them to get out of the building, and they refused, and they continued operations, and they were still using the Burger King stuff. And in this particular case, it was filed in the Federal District Court of Florida, and the court found for Burger King under these long arm statutes. The Court of Appeals came back in and said, no, we're reversing this. And so now it went to the Supreme Court. All right, so was Florida proper for jurisdiction for an out-of-state franchisee in this particular case? And they said yes. Okay, so they're not looking at the contracts alone, even though they could probably sit there and argue it that, hey, you entered into this contract with this Florida corporation and possibly do it that way. But they did weigh other factors, and the court came back and they said, look, this long arm statute doesn't violate their due process to establish substantial and continuing relationships with Burger King's headquarters in the forum state, which was Florida. Again, we're looking for something that's happening consistently. So as long as this franchisee is making their monthly payments and they're submitting them to the headquarters and everything that they're doing is with the headquarters, then that is where they can come in and say it is systematic and continuous. They would say, also, look, you received fair notice because just like that other, the National Equipment Company, you have fair notice from your contract, okay? You know where this is supposed to be. Even if you don't actually know, you have enough knowledge to know that you should go to your contract and look at that. And then you also have the course of dealings. And with businesses, this is a term that will come up a lot because they will look at how the businesses conduct themselves. And the longer the relationship, the more of a history that they have to rely on. And so they would say that during the course of these dealings, they might be subject to a suit in Florida. They would have known this. And they failed to demonstrate how jurisdiction in that state would be fundamentally unfair. And honestly, they couldn't because they had the systematic and continuous contact with that particular state. All right, so minimum contacts do not have to be physical. So it doesn't mean that you have to be, you don't even have to have any actual like clients and stuff like that. You could have it to where a company is simply advertising nationwide and they've been doing it for an extended period of time. That would be enough to be able to say, look, you're advertising to the people in that state. Therefore, you're subjecting yourself to this. It doesn't mean that it's going to fly, but it just means that that's an argument that can be put before the court. It also does not mean that the interests of due process are satisfied. Again, we're going to look at International Shoe. And it says very specifically, whether due process is satisfied must depend upon the quality and nature of the activity in relation to fair and orderly administration of the laws, which it was the purpose of the due process to ensure. So now let's look at what the court is going to actually consider. They're going to ask the questions, are these contacts substantial and are they purposeful? Now, with them being substantial, the more they have with the forum state, the more likely they're going to say that due process has been met. And money generated also is a factor here because this creates a benefit. So you might have only one contract in that state, but if that contract with that other company or that customer is generating you, $500,000 a year in sales, then that's going to be considered substantial. Now, with them being purposeful, if they purposely establish the contacts in the forum state, then the court has jurisdiction most likely. So that's like advertising to customers in that state. If they are doing this, then the court will come back and say, you know what? You've availed yourself to us. If not, then the nature of the business may be that it's reasonably foreseeable for them to take jurisdiction. And that's going to be something that's going to be up to the court to determine. Now let's talk about the Worldwide Volkswagen case. In this particular case, you have Woodson, who's a New York resident, and they buy a car from Worldwide Volkswagen. And they're now driving through Oklahoma to their new home in Arizona. Worldwide Volkswagen is in New York as well. They were rear-ended, ended up with a fire. They had severe injuries, things like that. But they brought the products liability case in Oklahoma. All right. Worldwide Volkswagen was incorporated in New York, and they only did business there. And they objected to the jurisdiction of being brought into Oklahoma. So, trial court rejected this objection, okay? Then they go in with what's called a writ of prohibition, and the Supreme Court is asking them to restrain the trial judge. Now we have the court denying this writ. Again, they're citing the jurisdiction that was authorized by their long arm statute. And the issue before the court was, could Oklahoma trial court exercise personal jurisdiction over Worldwide Volkswagen? And they said no, and the Supreme Court reversed it. Again, we're looking at, did they benefit from the state? Are there minimum sufficient contacts? Did they expect to be sued in the state in the event that something happened? And in this particular case, they did not. They did not have minimum sufficient contacts because, and they may have sold, 100 cars that people from New York had moved to Oklahoma. But that 100 cars, that didn't mean that they said, hey, I'm subjecting myself to the jurisdiction of that court. They did it in New York, and those people just happened to move. And so again, they might have had those sufficient contacts by sheer number of people. But again, we're looking at all of the bigger picture here. And so they just didn't avail themselves to the state. So now we're looking at, are these contacts systematic and continuous? And are the contacts and underlying cause of action related? So with it being systematic and continuous, the more you have, the more likely they are to take jurisdiction. All contacts do not have to be systematic and continuous either, okay? This is where we go back to that money factor, because a single contact can be enough depending on the size. So if it is a customer that is giving you $500,000 in revenue and you're doing business with them on a regular basis every single month or whatever, that is going to be enough. Now, when it comes to the contacts and the underlying cause that's of action, the less related it is, the less likely it's going to be, they're going to take jurisdiction. Now, other factors that the court will consider are the witnesses and evidence readily available, or at least somewhat conveniently available, and is the forum state actually interested in taking on the action? With the witnesses, if it is not readily available, or at least somewhat conveniently available, then it will be less likely that they will take jurisdiction. Now, if the forum state is interested in the action, yes. If yes, it'll be more likely. Now, where there is real property, they will have way more interest in protecting any kind of real property than they would any kind of personal property, which would be like jewelry, cars, things like that. Now, your domicile versus your residence, it's not always the same thing. And that's because you can have many residences, but only one domicile. So your domicile is a fixed place where you plan to be for an extended period of time, even if that's not always the case. And your residence is a temporary place. Example, you have a kid who goes to college. Like my daughter is going to be starting college in the fall, and she's going to be going to Jacksonville State in Alabama. So while she's there, she's going to take up residence in a dorm. So that's going to be her residence. But her domicile is still going to be here because that's where she lives when she's outside of school. So it's essentially the mailing address versus the permanent address. Other factors considered when it comes to domicile and residence and your tortious acts in the state. With the domicile, even if they're absent from the forum, if they are domiciled here, then jurisdiction can be exercised. So with like my daughter, she might be technically living over in Alabama, but if she happens to say get into an accident or something here, and then it comes up while she's over there, they will still take jurisdiction and bring her back. With residents, it is only allowed by some states, and most of them have passed laws because you do have people who travel through states. And so without these kinds of laws over the non-resident motorists, they would have no ability to necessarily bring them in. Now, tortious acts in a state, tortious acts, if you haven't had torch yet, that's your personal injury laws, which are going to cover everything from your intentional stuff, like where you beat somebody up or you go on their property, to your negligence type stuff, which are going to be like your accidents and whatnot. And then you have like your defamation claims and other things. But these are going to be things that involve personal injury. And most states have passed laws that are going to cover the jurisdiction over them if they have committed the tortious act. So you can use the state to where the action happened to bring somebody back in. Now, with procedural due process, you have to give adequate notice. That's going to be your summons. You're going to tell them that they have to have an answer back in, but either way it goes, they've been sued. The defendant has to have the opportunity to be heard, so they will issue an order that goes with it, and it'll tell them, like, you have to be at this particular court on this particular date, at this particular time, so that they have the ability. It even says on there so that you can tell the court why the plaintiff's prayer should not be answered. Then, if applicable, they have to have the opportunity to assert a defense, and that's where they are given the ability to do that, like with their answer and whatnot. If they happen to miss it, they can ask the court for permission to be able to file it, but it doesn't mean that they're going to get the opportunity to. And then it is accomplished through service of process. So you'll have them served with the summons and the complaint with the service of process. Now, in rem jurisdiction is what gives them authority to determine title to an object or real property. In rem jurisdiction, again, this is where we're looking at property titles. It can be personal, it can be real. Courts are essentially asked to determine the rights of the parties. Typically, it's used where you have unknown claimants, and this is going to be very different from the quasi in rem, which we'll talk about in just a second. Now, you have 5 conditions that have to be met, okay? It has to be something that's valuable. It has to be located in the court's jurisdiction. The court must have control of the property before exercising in rem. You have to also satisfy procedural due process, and you have to satisfy substantive due process. Now, circling back to the court having or control of the property, it's not actual possession. They can't go and pick up a piece of land, like for real property, and bring it into the court or anything like that. But they just have to have control of it to the exclusion of the party. So we're making sure that, there is a way for them to be able to enforce this judgment with the property, and it's not going to attach to the actual person. This is what's going to kind of set this apart from the quasi and rem also. With satisfying procedural due process, parties who have an interest have to receive a notice and an opportunity to be heard, which is going to be your summons. And you can do a service of process through publication in the event that you don't know where the person is. Now, it does say that these can be unknown parties. I want to point this out right here, that you can go ahead and sue, and you absolutely should file suit if you're coming up against like the statute of limitations on something. And that's because you don't want those to run out just because you don't know who someone is. So what you do is you file it against a Doe defendant. It would say something like, Amy Davis versus Doe defendants 1 through 99. And that gives me 99 slots to go back and fill in. I'm probably not going to need them, but nonetheless, it still gives me the ability to go in and sue as many people as I need, up to 99. I can also add in there defendant or Doe corporations, in case there's somebody who, might be employed somewhere. Maybe you got hurt at a location and you don't know the exact property owner. For example, a lot of parking garages and lots and stuff like that, they have an owner, but you may not necessarily know who the owner is. In fact, when we were up in Gatlinburg last year for spring break, my son's car got hit while we were in the parking, or while we were, out doing things, and he was parked in this parking lot. And so I walked over and I asked them for the name and the address and the phone number for the owner. And they told me flat out they wouldn't give it to me. And I said, do you guys have cameras here? And they said, yes. And I said, okay. And you won't tell me like who owns it or anything? Like, I just want to make sure that you guys keep a record of who was, of this particular, footage. And that's called a notice to preserve evidence. And anyhow, but they wouldn't give it to me. So that's one of those things that sometimes you need to get it in because there's only a certain amount of time. And it might be that you just need a little bit more to be able to kind of look through, because it might be a company that owns a company that owns a company that owns a company. And you just got to keep peeling back the layers to figure out what's what. But maybe it was in that particular situation, maybe it was an employee who actually did the, caused the damage to my son's car. And in that particular case, you would want to make sure that you added on the Doe Defendant Corporation, because of the simple fact that you want to be able to sue for the negligence of their employees as well. So it'd be like Amy Davis versus Doe Defendants 1 through 99 and Doe Corporations, 1 through 10. And that would give you the ability then to also go back and add those as well. With substantive due process, this is simply met by having an interest in the property. The state's going to have that. Examples: foreclosures of liens, partitions. A partition is where you have, say, person A and person B, and they own 200 acres of land. And it's not, it's not specific acres. Like, you don't own 100 acres to the left and they own 100 acres to the right. It's that you guys jointly own 200 acres. So a partition is where you go into court and you ask them to designate and basically slice it up and give me which ones are mine. And then you also have quiet title actions where somebody's claiming an interest in a property, but they're not actually the owner. Now, quasi in rem allows the court to force a litigant to appear by attaching property that is owned by the litigant. So this is used where the court takes property, and again, they're forcing the owner into court if the person wants it back. All right? They're not subject to the court otherwise. It is similar to in rem, but the identities of the defendants have to be known, or at least identifiable on some level. It can be brought in any state where assets exist. Let's look at an example. Lucy and Jeff got into an accident in Georgia where she is a resident. Jeff is a resident of Florida, and he files suit in Florida since Lucy owns a beachfront condo in the state. Is this proper? Yes. This is where we're going to use quasi in rem because it's jurisdiction over the property. And this is where we have the court saying, show up, pay the man, or we're going to take your property and pay the man. We know who it is because she's identifiable or known. And again, they have jurisdiction over that particular property. Now, with quasi and rem, we have 6 conditions to meet here. It has to be valuable. It has to be located in the court's jurisdiction. The defendant has to have an ownership interest in the property. The court must control the property before exercising quasi and rem. There has to be satisfied procedural due process and substantive due process. Now, with it being valuable, with quasi and rem, it is only up to the amount that is valued. And I'll show you what that means in just a second. With it being located in the court's jurisdiction, this is satisfied by the seizure of the property. You can have intangible property, but it does have its own issues. And this also comes up in contracts. Intangible property is going to be like stocks, bonds, insurance, intellectual property like your patents, your copyright, trademarks, things like that. So the states are going to vary when it comes to the actual location of the certificates that represent these things, but they're going to look basically for the location of the actual corporation itself. Now, with substantive due process, there has to be a contract between the litigant and the forum state, or the seized property has to have some relation to the cause of action. And that's because we're going back to international shoe. We want to satisfy the notions of fair play and substantial justice. For example, Lucy and Jeff got into an accident in Georgia where she is a resident. Lucy is a resident of Florida. He files suit in Florida. She has a bank account with the Bank of Florida where she keeps $100,000 in it. The accident caused $150,000 in damage to his car and injuries to him, and so he files suit in Florida. Is this proper? To an extent, yes, because quasi and rem, she's known, it allows for jurisdiction over the property. But in this case, because it's quasi and rem, he can only get up to the $100,000. He's still out the $50,000, and he's going to have to turn around and figure out where to sue for that money. Now, subject matter jurisdiction means that the court has the authority to hear the actual case. All right, so you have 2 types. You have general jurisdiction, and then you have limited jurisdiction. Your general jurisdiction is going to be like the Superior Court, where they have the power to hear any case, okay? For state courts, they cannot hear matters that belong in federal court, but you can hear some matters in federal court that can also be heard in state court. That's a different beast for a different day, though. Limited jurisdiction is where they have the power to hear certain types of cases, like bankruptcy, probate, juvenile. You have magistrate court, which is going to be like your small claims type stuff. These are going to be a limited jurisdiction. Courts can have jurisdiction over multiple counts, but not the last one, okay? And if you have a situation where something like that comes up, they can only hear the ones that they have jurisdiction over. So that means that somebody has to turn around and file in another court for the other outstanding count. Or it might be that they have 10 counts and they can hear, all of the odd numbered ones. So all the even numbers are going to have to go into a different court. Just so you understand the principle, it's not necessarily literally the last one. It cannot be consented to or applied due to failure to object. Subject matter jurisdiction is set. There is no negotiating this particular factor. It can be objected to at any time versus personal jurisdiction has to be objected to at the beginning. So if you find that something is filed in the wrong court under subject matter jurisdiction, it doesn't have to be set out from the beginning, and then you have to go in and ask, the court for permission if you don't file it in the beginning, and then hope that they give you permission. Again, this is any time. Now, federal courts require either a federal question or diversity jurisdiction. With a federal question, it means that there is something with federal law or the Constitution, okay? Diversity jurisdiction is where you have no plaintiff and defendant are going to be citizens of the same state, and You have to have an amount that's in controversy. So that means you're asking the court to award you something over $75,000. Now, federal questions are going to be things like, say, bankruptcy or your intellectual property. Now, you can file intellectual property on the state level as well, but for this particular purposes, we're going to assume that it's on the federal level. Now, cases like admiralty and bankruptcy, those have exclusive jurisdiction. So like bankruptcy court cannot hear any other type of case. It is specifically bankruptcy and bankruptcy alone. You can also have concurrent jurisdiction with state courts. And that's because it might be something that could be filed in either state or federal court. This will also come up in criminal law or particularly criminal procedure, where you might have something that has, say, a murder charge that happens. Actually, let's use RICO, because RICO has like been in the news a lot. You can have state level RICO and you can have federal RICO. So you've got things like that where they're going to kind of run parallel. And it doesn't mean that you're in double jeopardy or anything like that, because they're two different states. They're two different charges, or not two different states, rather, two different jurisdictions with two different charges. So they're not going to be charging you with the same thing, even though they might have the same exact, elements that are required. But we're not going to get into all that. Now, with federal questions, the allegations of subject matter have to be in the complaint. There is absolutely no minimum amount that's required here. There's no requirement for parties to be citizens of different states. And where the plaintiff fails to plead a federal question, and they now plead a state law that is trumped by federal law, then the defendant can remove it to federal court, rather. So, for example, let's say, out in Colorado where you have legal marijuana, but it's only legal on the state level. And on federal property, you still have the whole, it's still against the law federally. But anyhow, this would be something to where you have a state law that is trumped by federal law. And so in this particular case, if you're suing over something like this, it could potentially be moved into federal court. But that's just an example. It's kind of a bad example, but it's the best one that I could give you off the top of my head at the moment, for where there's a state and federal that go together. Now, diversity jurisdiction, you don't have to have any question of federal law, but you can have concurrent jurisdiction with the states. If diversity is satisfied, though, is the only time that you can file it in federal or in state. Plaintiff and the defendant have to be citizens of different states, and the citizenship is determined by the domicile. Remember, that is where you intend to be for a fixed period of time. It's where you go and you buy a house and you have a mortgage on it. You might know that you're only going to be there for 5 years because your job's supposed to transfer you, but nonetheless, that is your domicile for all intents and purposes. The amount in controversy has to be greater than $75,000 minus any kind of costs and interest. So you have to have $75,000 and a penny to get, this thing going. This does not have to be an actual amount. It just means that there is the potential to have $75,000. So the court could find that it's actually less, and that's fine, as long as you're not lying about it and going in and claiming $75,000 just to be able to get it into federal court. And diversity has to exist just at the time of filing. For example, John is a citizen of Canada. He met Amanda at medical school in Mississippi. They got married and lived in the home where she inherited from her father. After medical school, they had to start the residencies. We went to New Mexico for 2 years. He got a fellowship that took them to Georgia for 2 years. Now they live in an apartment that they rent from Lewis, who's a Georgia resident. And he installed cameras in the apartment and filmed them. They filed suit in federal district court in Georgia for $100,000. Lewis filed a motion to dismiss for a lack of diversity, and it was denied. Was this proper? Yes. Because remember, it has to exist at the time of filing, and it's based on your domicile, okay? not your residence. So when they went to New Mexico and they're there for 2 years to do their residency, and then they know they're going to another place for a fellowship and they're following this whole little path, okay, this is a situation to where they know that it's like super temporary, and they know that they're doing it for like this specific situation. Now, I know you're probably thinking, but you just gave us an example about what if you buy a house and you know you're only going to be there for 5 years. You bought a house. You're not renting. That is a huge difference because you're putting a mortgage on the place versus it being something that is considered more temporary. So in this particular case, Amanda did not have, her domicile was technically in Mississippi because she lived in the home that she inherited from her father. And her husband in this case was still a citizen of Canada, even though, he was with her there. So again, we have the diversity is met in this particular case. Now, Lucy and Jeff got into this accident in Georgia where they're both residents. And 6 months after, she moves to Florida because she bought a condo on the beach and he filed suit in Georgia. Lucy filed for a motion to dismiss due to a lack of diversity, and it was denied. Was it proper? Yes, because the diversity just has to exist at the time of filing. So she can move back whenever she wants to, but diversity is still going to exist. Ben, Michelle, and Sean are citizens of Georgia, and they filed suit against Dave, Todd, and Marie, who are citizens of Alabama. Does diversity exist? Yes, because we're just looking at one side versus the other. You can have all plaintiffs be the same, and you can have all defendants be the same. They just cannot cross over. Ben, Michelle, and Sean are citizens of Georgia, and they filed suit against Dave, Todd, and Marie. Dave and Todd are citizens of Alabama, and Marie is a citizen of Georgia. Does diversity exist? No, because Marie is a defendant who shares the same citizenship with the plaintiffs, so she has crossed over. We can't do that. Now, Ben, Michelle, and Sean are citizens of Florida, Georgia, and South Carolina, respectively, and they filed suit against Dave, Todd, and Marie, who are citizens of Alabama, Tennessee, and Kentucky, respectively. Does diversity exist? Yes, because absolutely no parties share the same citizenship. Now, with diversity jurisdiction, remember, we are looking for more than $75,000 when the case is filed, and I cannot stress enough that it is less the interest and costs. Now, again, you don't have to prove the amount. You just have to show that there is the possibility that this amount exceeds $75,000. It can be an aggregate claim, and I'm going to show you what that means. If the case was never worth $75,000, though, the court can, come back and punish you and, impose those costs on you. So Emily is a citizen of Georgia, and she's filed a complaint against Sam, a citizen of Tennessee, for injuries that were the result of a car accident. She's seeking damages for the loss of her car, $15,000, damages related to her injuries of $45,000, and lost wages for $15,000. So that adds up to $75,000. That is an aggregate total. It just means simply that you have added it up. Does diversity exist? No. Okay. They don't share citizenship, but it has to be $75,000 and a penny. Now, Glenn and Barb were rear-ended by Lynn, and they were residents of Georgia, and Lynn is a citizen they are citizens of Georgia, and she's a citizen of Florida, and they filed suit for their injuries. His were $30,000 and hers were $50,000. Now that adds up to $80,000. Does diversity exist? No, because this is not even though you can add it up and you can make it so that it's more than $75,000 and the citizenship part is met, these are two separate sets of injuries. Now they come from the same incident, but they're still for two individual people. So his have to be more than $75,000 and so do hers. Now, Laura and Paul are citizens of Tennessee, and they had their home burned down due to the negligence of Tammy, a citizen of Alabama, and they filed suit. And their loss was a total, or the loss of their house rather, was a total of $200,000, and each claimed $100,000. Does diversity exist? Now, this is 100% unlike the previous example because this is their home that they share together. So we have the citizenship part that's met. And now we have an aggregate total that is more than $75,000. And it is one injury, it is one house that they both own. Now, with corporations, they can be citizens of two different states. Go back to International Shoe. It was incorporated in Delaware, and it had its principal place of business in St. Louis, Missouri. Same thing here, example. It's incorporated in Delaware, but the principal place of business is in Georgia. They can only have one principal place of business, though. It's where the headquarters is located. That's going to be considered a nerve center test. And then you have where the majority of the assets are. That's going to be the muscle center test, but we don't use that one anymore. So the two type of tests are the nerve center, and this is where it says that the headquarters is where the decision-making authority is and overall control is, because that's where your executives are. And then you have your corporate activities test or the operating assets test that says greater weight is given to the location of production of service activities to determine the principal place of business. Going back to the nerve center, this is based on the Hertz case, and this is where the Supreme Court says this should be the only case or the only test that gets applied. Again, that's because we're looking at the fact that this is where the executives are, and therefore this is the overall control. So this is the brain. This also means that national corporations cannot be citizens of all 50 states. So you can have companies like Walmart where they have, thousands of stores and they're spread out all over all of the different states, but they still only have one domicile or one principal place of business. You can have like where they incorporated at be different than their, the nerve center. Sole proprietors, they don't have a place of incorporation, and that's because they're themselves. Some partnerships are considered unincorporated associations. With diversity, you have to determine the citizen of every member, and the association is going to now adopt each one of those states as its domicile. And that does include DC, Commonwealth of Puerto Rico, and other territories. For example, Acme Partners is owned by Jennifer, a resident of Georgia, Joe, a resident of Alabama, and Sue, a resident of Alaska. So they are domiciled in all three states. So where the United States is a party, it is determined by statutes that allow for the government to be sued. Take that in. You have laws that determine whether or not the government can be sued. This is under sovereign immunity, and it means that you can't sue without their consent. So you have to literally go to the government and say, you know what, I'm putting you on notice. I really want to sue you. So give me your permission. That's not always the case. The Federal Torts Act does change that a bit and lessens it up, but still, again, take that in. Supplemental jurisdiction is also an option, and this is where the court does not normally have jurisdiction, but it obtains it by a claim that it does not have original subject matter jurisdiction over to a claim that it does have original subject matter jurisdiction over. And I know that sounds like a hot mess, but an example would be Jeff, a citizen of Georgia. He's filed suit against Holly, who's also a citizen of Georgia. And he chose to file the case in federal court, and he's claiming 2 counts. So there's a trademark violation and a personal injury. Jeff stated that Holly had used his registered trademark for her store name. He also stated that he slipped and fell on some water in Holly's store when he was checking out the trademark use. So, does supplemental jurisdiction exist? No. These are 2 claims that are completely unrelated. Now, Jeff's a citizen of Georgia, and he's filed against Holly, who's also a citizen, and he chose to file in federal court. Now he's filing for trademark violation and copyright violation. And he stated that he had used his registered trademark, or that she had used registered trademark for her store name. He also claimed that she was using his copyrighted artwork. Does supplemental exist here? Yes, because you have claims that are related. Now, venue is literally where the litigation may take place. It uses greater precision than jurisdiction. It is based on a geographic area. So, for example, like I said earlier, we're looking where we file if both parties are in Georgia or all parties are in Georgia. You're going to look where the defendant lives. Now, you might have multiple defendants. You might have one that's in DeKalb County, one that's in Cherokee County, one that's in Fulton County, and in that case, you can pick one. But it does usually depend on where the defendant lives. It could also be where the cause of action arose. So if you have a tort claim, like maybe a car accident that happens over in Cobb County, then you could potentially use that as your jurisdiction. It's where the tort occurred. Well, cause of action, let me back up. Cause of action could also be something like a breach of contract case. But it is also where a tort occurred, because when a tort happens, that is also a cause of action. Where the defendant does business. So it might be that they live in DeKalb County, but they do business in Cobb County, and you might be able to stake a claim there. It can also be consented to in Georgia. So you can ask somebody who lives in a completely different county to consent to the venue of this particular county's court. State actions. So general rules for most jurisdictions are that if all parties reside out of the state, then venue is going to go to where the cause of action happens. So if there's a car accident, it's going to go to that particular county. If it's for real property, then it's going to be where the property is located. Where one or more party lives in the host state, again, you can pick either of them, just like I just said. Venues are determined by statutes under federal actions. An example would be like intellectual property cases. Those can be brought in the district where the defendant lives, where their agent lives, or where they can be found. It can be where they're doing business, things like that. The forum non-convenience. This simply means the inconvenient forum. Remember when I said earlier about with the minimum sufficient contacts, is the evidence readily available, or is it convenient? What about the witnesses? This is where this is going to come into play. Venue can be proper, but it's not as convenient or appropriate as another one. And in that case, you can move it. It does require an adequate alternative in order to ask the court to allow it. So you can't just go and pick another, county or anything like that. There has to be a reason, basically, that you are moving it. Two factors are considered on motion. There's public interest and private interest. Public interest factors are going to be having local disputes settled locally. You want to keep it, where it happened. It does avoid the problems of applying foreign law, and it avoids burdening jurors with cases that have no impact whatsoever on their particular communities. Will another jurisdiction actually enforce a judgment made by another court? Now, they're supposed to, because there's a full faith and fair credit clause where they are supposed to give, they're supposed to enforce judgments as if it is as if it was one that they had done themselves. But again, this might be something that just, you have to basically work your way through the system. So Anthony is walking and falls on a crumbling sidewalk outside of Rick's store in Marietta. Both are residents of Marietta as well. Anthony files suit in the state Supreme Court located in Fulton County. Rick invokes the forum non-convenience. Will the judge grant it? Most likely, because they're both residents of Marietta. It happened in Marietta, all of that stuff. Also, state court is not appropriate for this type of thing anyhow. Now, with private interest factors, you have the ease of access to evidence, cost for witnesses to attend the trial, availability of compulsory process, and any other factors that might shorten the trial or make it less expensive. And that's it for this particular lecture. I know it's something that if you've been through 1100 already, you've heard it there. You've probably heard it in some other cases or in other classes as well, where we have to talk about this and how it applies to that particular area of law. But nonetheless, again, it's so very important to civil litigation. So I, had to basically reiterate the fact that this is something to pay attention to, because again, it is something that can get your entire case completely thrown out. Or it might be something that you're, going to try to get something thrown out. Anyhow, if you have any questions, just reach out and ask me, and I'll be happy to answer. Have a good one.